Hey everyone, it's Lucas here, and welcome back to Immigration News with Lucas. Now listen carefully.
Are you dreaming of getting your U.S. green card through the EB-1 category, the one reserved for top professionals, extraordinary achievers, and outstanding researchers? Well, there's some huge news you can't afford to ignore. The EB-1 visa rules are officially changing in January 2026, and if you've been planning to file, now is the time to act because waiting could cost you your opportunity. Let's break this down. The EB-1 category is one of the most powerful immigration pathways to the U.S. It's designed for individuals at the top of their field: scientists, entrepreneurs, artists, executives, and academics who've made a real impact. But here's the twist. New regulations are on the horizon, and according to multiple credible immigration sources, they could tighten eligibility, raise evidence standards, and slow down processing times. Imagine this right now. Your achievements might qualify you under the current interpretation of extraordinary ability. But after January 2026, the very same profile could fall short. USCIS is expected to redefine key terms like sustained acclaim and national significance, and many petitioners who would easily qualify today might find themselves locked out tomorrow. And let's not forget about retrogression, with more people rushing to file before the rule change. Priority dates could backlog faster than ever. Those who file early could secure their place in line, while late filers may face years of waiting. So if you've been hesitating, thinking you have time, you don't. The window to take advantage of the current EB-1 rules is closing fast. The smart move is to start your petition process now, work with a qualified immigration attorney, and make sure your application is strong before the 2026 change hits. Stay tuned, because in this video, I'll explain what's changing, who will be affected, and exactly how to prepare before it's too late. And before we dive in, hit that like button. It helps this information reach more people who need it, and it shows me you want more crucial updates like this one. Let's dive in. You've just heard the news. The EB-1 visa rules are changing in January 2026. And if you're serious about immigrating to the United States through this highly competitive category, what you do in the next few months could completely shape your future. This isn't hype, this is the reality. The EB-1 category, often called the Einstein visa, has been one of the most direct and powerful paths to a U.S. green card for exceptional individuals. But with new regulations on the horizon, things are about to get more complicated, and waiting could literally cost you your dream. So let's unpack what's happening, what's expected to change, and what steps you need to take right now, not next year. Not when the announcement becomes official, but now, while you still have time to take advantage of the current rules. First, let's start with what the EB-1 visa really represents. It's divided into three main subcategories: EB-1A for individuals with extraordinary ability, EB-1B for outstanding professors and researchers, and EB-1C for multinational executives and managers. Each of these categories has its own criteria, but they share one thing in common: they're reserved for people at the top of their game. These are individuals who've achieved excellence, people whose work has left a mark in their field. But here's the thing: extraordinary is a subjective word. Over the years, USCIS has had flexibility in how it interprets who qualifies as extraordinary. That's been both a blessing and a curse. It has allowed truly talented people who may not have global fame to still get approved, but it's also created inconsistency in how officers evaluate cases. That inconsistency is one of the reasons why these new rules are being drafted to standardize and tighten the process. Now, on paper, standardization sounds fair. But in practice, it often means stricter interpretation and fewer approvals. What we're hearing from policy analysts and immigration attorneys is that starting in January 2026, the Department of Homeland Security and USCIS plan to update their definition of extraordinary ability. That means new language, new examples, and possibly even new evidence categories. For instance, under current rules, you can qualify for EB-1A by meeting at least 3 out of 10 criteria, things like winning awards, having your work published in major media, judging the work of others, making original contributions, or leading in distinguished organizations. But under the upcoming framework, there's talk of increasing the evidentiary threshold, possibly requiring 4 criteria instead of 3, or redefining what counts as a major contribution. Imagine how that changes the game for thousands of applicants who right now would easily qualify. And it's not just the criteria. The standard of proof may shift from preponderance of evidence to something more rigid. Officers could be instructed to scrutinize each piece of evidence with a higher bar for what counts as significant recognition. For many applicants, especially those in emerging fields like tech startups, digital media, or AI research, that could make it harder to prove impact without decades of history or traditional awards. Now let's talk about timing. USCIS has a history of implementing rule changes that trigger what's called a filing surge. That's when everyone who's been sitting on the fence suddenly rushes to file before the deadline. The result? Processing backlogs. So, while technically the rules change in January 2026, the practical impact could start much sooner, as early as mid-2025, because petitioners, attorneys, and even employers start crowding the system to lock in their cases under the current standards. Here's the harsh truth: if you wait until late 2025 to file, you may already be too late. The flood of applications will slow everything down. Priority dates could retrogress, meaning even if your petition is approved, you might have to wait years for a visa number. And remember, EB-1 is supposed to be current most of the time, but surges have changed that before, especially for countries like India and China. So, if you're from one of those high-demand countries, the window is even tighter. Let's pause for a moment and think about what this means for you personally. Maybe you're a researcher publishing groundbreaking work. Maybe you're a business executive leading international operations. Maybe you're an artist whose influence is growing fast. Right now, under the 2025 rules, your profile might be a perfect fit. But in 2026, when USCIS updates its policy manual, that same portfolio could suddenly fall short. A paper in a mid-tier journal might no longer be enough. A regional award might not count as national recognition, and your media coverage might need to come from globally known outlets, not just niche publications. This is why immigration lawyers are already advising their clients. If you're even thinking about applying for EB-1, start preparing now. Collect your evidence. Build your case. Get recommendation letters from high-profile experts. The sooner you file, the better chance you have to qualify under the current interpretation before the rules shift. Now, let's discuss what's driving this change. Over the last few years, the number of EB-1 filings has grown dramatically. The category has become increasingly popular, especially among international professionals who once relied on H-1B or EB-2 routes. With more people applying, USCIS has been under pressure to refine what extraordinary truly means. Critics have argued that the EB-1 has become too broad, that people without genuinely elite credentials have been slipping through the cracks. That perception, fair or not, has led to this regulatory overhaul. But here's the other side of the story: these changes might also be politically motivated. Immigration reform is always a balancing act between national interest and public perception. Tightening EB-1 criteria gives the government a way to appear tougher on immigration, while still promoting merit-based pathways. The message becomes, we're still welcoming the best and brightest, just with higher standards. So, even if you're genuinely extraordinary, you'll need to prove it more convincingly than ever. That brings us to another critical point: documentation. Under the proposed framework, officers are expected to rely more heavily on objective, verifiable evidence and less on subjective judgment. That means your application has to tell a crystal-clear story. Every piece of evidence must connect logically to the narrative that you're not just good, you're exceptional. That your work isn't just relevant, it's influential and recognized by your peers. Think about your citations if you're a researcher. Think about your media footprint if you're an artist or entrepreneur. Think about the scope of your leadership if you're an executive. The stronger and more measurable these indicators are, the better. Under the new rules, weak or borderline evidence might not make the cut. There's also talk that USCIS could start requiring more ongoing impact evidence, not just past achievements, but current influence. So if you won an award years ago, but haven't stayed active in your field, that could weaken your case under the 2026 rules. Consistency and relevance might become just as important as prestige. Now, let's look at what you can do between now and January 2026. First, get your documents in order. Gather proof of your achievements letters, press coverage, patents, contracts, or awards. Second, hire an experienced immigration attorney who's handled EB-1 cases successfully. They'll know exactly how to frame your narrative and meet the legal standard. Third, don't wait for the final rule to be published. Policy updates often come with short notice, and once the rule is live, there's no going back to the old standard. You also want to keep an eye on visa bulletin updates. The State Department releases these every month, showing current priority dates for each category. If you see movement or early signs of retrogression in EB-1, that's your signal to act immediately. Now, I know what some of you might be thinking: what if the changes aren't that bad? What if it's just a clarification? That's possible. But think about it like this: what do you lose by filing early? Nothing. Waiting, on the other hand, could cost you everything: eligibility, timing, and years of waiting in backlog. Let me give you a quick real-world example. Back in 2022, when the Department of Labor updated the PERM process and tightened requirements for certain professional occupations, thousands of applicants who waited even a few months found themselves excluded. The same pattern happens again and again: proactive applicants benefit, hesitant ones fall behind. And the emotional toll of waiting shouldn't be underestimated. I've spoken to so many professionals who plan to apply next year, only to find the rules shifted and their profiles no longer met the bar. They had the talent, the work, the recognition, but timing wasn't on their side. You don't want to be in that position in 2026. So, let's get real. You have roughly a year left before the change takes effect. That may sound like plenty of time, but in the world of immigration filings, it's not. Between gathering documents, drafting petitions, obtaining recommendation letters, and waiting for attorney review, the process can take months. If you start in early 2025, you'll be cutting it close. The ideal time to start preparing is right now. And if you're watching this video because you're uncertain whether you qualify, that's even more reason to act fast. Get an evaluation. Many attorneys offer a free or low-cost consultation to assess your eligibility. They'll tell you if you have a strong case now and what steps to take to strengthen it before filing. Even if you're not ready to file tomorrow, having a strategy in place gives you a massive advantage over those who wait until the last minute. Let's also address a common myth that EB-1 is only for geniuses or celebrities. That's simply not true. Many EB-1 recipients are regular professionals who've built impressive track records over time: professors, startup founders, engineers, researchers, and executives. What matters is how well you can document your achievements and frame your impact. The EB-1 isn't about being famous, it's about being verifiably outstanding. And the current system still allows flexibility for that. But after January 2026, that flexibility might be gone. Now, here's where the urgency really hits home. When USCIS tightens a regulation, they often also release new policy memos to guide adjudicators. These memos interpret how officers should evaluate evidence, and once they're in place, they influence every future case. So even if your petition is technically filed before the rule change, if your case isn't yet decided, it could still be evaluated under the new framework. That's why timing and strategy matter so much. You want your case filed and ideally approved under the current definitions, not hanging in limbo during the transition. Some experts are even predicting that the 2026 change could create one of the biggest EB-1 rushes in history. As more people from countries with long wait times turn to EB-1 as a faster route, the demand will spike. That surge will inevitably lead to backlogs, even for countries that have historically remained current. So the earlier you file, the better your place in line and the faster you move toward permanent residency. So here's the bottom line. The EB-1 visa remains one of the best options for talented professionals worldwide. But it's about to become more competitive, more complex, and more rigid. The winners will be those who act early, prepare thoroughly, and don't wait for the change to catch them off guard. Don't assume you'll have time to adapt once the rule drops, because by then, it'll be too late. You're not just competing with applicants from your own country, you're competing globally. Every month counts. Every delay could mean getting pushed behind thousands of other applicants trying to beat the same deadline. So if you're serious about immigrating, make this your moment to move. In this video series, I'll be breaking down everything you need to know. What exactly the 2026 EB-1 rule changes include, how to build a strong case under the current rules, and how to navigate the process like a pro. So stay tuned, because I'll walk you step by step through each stage. And listen, if you found this video helpful or it opened your eyes to how urgent this situation really is, do me one favor, hit that like button. It helps this video reach more people who might not even know these changes are coming. And trust me, they'll thank you for helping them get this information in time. So like the video, drop a comment below if you have questions about your EB-1 eligibility, and make sure to subscribe so you don't miss the next update. The clock is ticking, my friend. January 2026 isn't far away, and your opportunity to file under the current rules is slipping day by day. Act now, prepare smart, and secure your place before it's too late.